Hi everyone, my name is Natalia. I'm Sumsub's AI compliance specialist. In my last video, we discussed a little bit about the basics of AI regulation, as well as we did a deep dive into the EU AI Act. Today, we are going to be focusing on what other jurisdictions are doing in terms of AI regulation, such as China, the UK, and the US. By becoming familiar with what these countries are doing, we get some analytical tools that help us to decode what other jurisdictions are doing in terms of AI. I'm going to leave in the comments a couple of sources that I believe you're going to like to have a look on. For now, in this video, we are going to have a look, as I said, in the Chinese, British, and American regulatory frameworks on AI. Let's go. Starting by China, China is being very active when it comes to AI regulation. In 2017, the country released a report called New Generation AI Development Plan, in which China stated its goals to become a global AI leadership, including the idea of becoming a champion in terms of AI regulation. Ever since, the country has enacted 3 different AI regulations. So, first, the Internet Information Service Algorithm Recommendation Management Provisions. Second, the administration of deep synthesis of Internet information services. And thirdly, the administrative measures for generative AI services. The main driver behind all this regulatory strategy is the Cyberspace Administration of China, CAC, the Chinese Internet regulator. So first of all, when we're talking about Chinese AI regulation, they tend to be very detailed and very prescriptive. One of the reasons behind it is the idea that while in the EU, as we saw in the last video, the regulation is cross-sectoral, it's horizontal. In China, the regulators have preferred to regulate AI applications one by one. Secondly, given Chinese political culture and social preferences in general, the regulations about AI in China, they tend to have a focus on protecting public security and the national interest over provisions regarding individual human rights. Chinese regulation, they tend also to be very future-proof and try to reach a certain level of scalability. So, for example, all the regulations, they build upon each other. So the structures that one regulation comes up with tends to be followed, tends to be applicable to the next regulations. We are going to start with the first one, the one regarding the Algorithm Recommendation Management Provisions, which entered into force in March 2022. So in general, it refers to the application of algorithm recommendation technology in the providing of Internet information services within the territory of People's Republic of China. Secondly, it also establishes that providers must register their AI models in China's algorithm registry, which is an online public-owned database that you're going to see coming up again and again over the next regulations we're going to talk about. The reason or the need, the motivation to ask some systems to be added to this database is only the systems whose algorithms has, according to the regulation, public opinion attributes and social mobilization capacity. This is a provision, I must note, that has the potential to facilitate a state's oversight over its population. Developers of algorithms with these capabilities that I just mentioned, they are required to submit information on how their algorithms are trained and deployed, including which datasets the algorithm is trained on. They're also required to complete an algorithm security self-assessment report. On the other hand, when it comes to the users, they have the right to be notified or to be warned somehow when they're handling an algorithm that is capable of making the recommendations. Another important provision of this regulation is that it prohibits the use of recommendation algorithms for illegal or harmful purposes as discretionarily defined by the Chinese government. Lastly, individual users were also granted new rights by this regulation. So users can output and turn off targeted recommendations, they can delete tags used to personalize recommendations, and they also are entitled, they have the right to receive an explanation when an algorithm has a major impact on their interests. So this is quite a broad regulation, and it's one of the first ever to be enforced and handles AI directly. Moving on to the second regulatory piece that I want to talk about today, it refers to the Deep Synthesis Regulation, which entered into force in January 2023. The idea is that deep synthesis refer in general terms to any content that is synthetically generated but does not necessarily have the purpose of deceive. Looking a little bit into the provisions from this deep synthesis regulation, I would like to start by highlighting that the regulation includes several very broadly, very vaguely defined censorship provisions that could impact civil liberties, such as, for example, the requirement that deep synthesis content must adhere to the correct political direction. Or a second provision to keep an eye on is the idea that any deep synthesis, so any deep synthesis content that has the potential to endanger national security and interest, damages the country's image, or infringe on social and public interests are also prohibited, according to Article 6. So, looking to some other key points of the regulation, I would like to highlight the certain transparency requirements. So, for example, the regulation establishes that when a deep synthesis content might cause confusion or mislead the public, the providers of that content must, and here I quote, preeminently mark the reasonable location and area of the generated or edited information content to remind the public of the deep synthesis nature of the situation. So China was one of the first countries to establish that in a legal manner. Other than that, the regulation also requires that providers of deep synthesis services must authenticate the users of the services. And lastly, it requires that deep synthesis providers, they need to also add their algorithms to the algorithm registry. One fun fact about this regulation is that it was roughly only a couple of days before ChatGPT was released into the world. And that was a huge game changer. Labeling content is a technique that might be less effective in cases of content that are not image or audio, such as the content provided by ChatGPT, for example. Aside from that, if you pay attention to this regulation's name, it explicitly mentions services offered on the internet. Therefore, it does not cover services that are offered offline, such as can be the case of ChatGPT. Because the regulation became slightly outdated quite quickly, the regulators came up with a third regulation, Administrative Measures for Generative AI Services. It entered into force in 2023, and it has a focus exclusively on generative AI services that are public-facing. And the regulation applies to, here I quote once again, the use of generative AI technology to provide services that generate text, pictures, audio, video, and any other content to the public within the Chinese territory. So there is also a certain arbitrary limitation to certain types of Gen AI systems that might, according to the regulators, incite subversion of state power or overthrow the socialist system. Certain Gen AI models must also be included in the algorithm registry. And lastly, in Article 7, it establishes some certain provisions that Gen AI providers must follow. So they need to carry out pre-training, optimization training, and other training data processing activities, as well as they need to ensure that they are using data and basic models that come from legal sources. If intellectual property rights are involved, they must make sure they are abiding by them. If personal information is involved, individual consent must be obtained or other circumstances that comply with laws and other administrative regulations. The providers of Gen AI services must also take effective measures to improve the quality of training data and enhance the authenticity, accuracy, objectivity, and diversity of training data. And lastly, other relevant provisions of laws and administrative regulations, they also must be in comply with. So when it comes to watch out for China in 2024 and in the future, I think it's pretty clear by now that China has this intent to position itself as an AI regulator champion, two tendencies to keep an eye on. In October 2023, China announced its Global AI Governance Initiative, which encompasses many policies through which China seeks to exert influence and launch its own benchmark in terms of AI regulation. And in 2024, January 2024, China Industry Ministry has already issued draft guidelines for standardizing the AI industry. So to wrap up, there is certainly a lot for us to stay tuned when it comes to AI policies and China. One of the strongest features about the UK's approach towards AI regulation is that they are leaving AI regulation to another day. So differently from the EU or China, the UK does not have yet a AI direct regulation that is binding. On the other hand, the country has issued a handful of guidelines, frameworks, and has showed that it intends to rely on existing regulators and existing regulations to address the concerns over AI in modern dance. Just last month, in February, the government published its response paper on AI regulation, reaffirming the line of action proposed in March 2023 with the AI white paper, which came into being known as an indicator of the UK's pro-innovation, pro-business approach towards AI. Interesting aspect of the UK's approach towards AI is the country's concerns over safety risks related to AI. This reflects the claims or the line of thinking for a movement known as effective altruism, which tends to focus on the long-term risks of artificial intelligence, having in mind the belief that AI has this potential of ripping all of us out of Earth.
At some point, the companies rushing headlong to scale AI will cough out something that's smarter than humanity. Nobody knows how to calculate when that will happen. My wild guess is that it'll happen after 0 to 2 more breakthroughs the size of transformers.
Last year, for example, as concrete evidence of this matter, the United Kingdom hosted the UK AI Summit, which was a government-sponsored event to discuss AI technologies and policies. At the end of it, one of the most concrete takeaways of this event was the signing of the Bletchley Declaration, in which 28 countries agreed to work together on AI safety research, and simultaneously, the UK also launched its AI Safety Institute, once again indicating the country's focus on AI safety. My choosing to focus on the AI white paper is that this one is probably the most useful for the private sector, but the UK has at least 2 other pieces that are quite interesting from a regulatory point of view, but that tend to focus on the use of AI by public agents in the country. So we have the Generative AI Framework, which is a guidance on using generative AI safely and securely for and by civil servants, and the Algorithm Transparency Standard, which was published in 2021 and is where the government launched certain transparency standards for government departments and public sector bodies. Moving on to the UK AI white paper. As I said, it was published in 2023 by the Department of Science, Innovation and Technology. The paper inaugurated what came into being the UK business approach towards AI, and it goes around mainly the achievement of 5 principles, or better, the recommendation for companies to abide by certain 5 principles. These principles are, first, safety, security, and robustness. So here is the idea that the systems should function in a reliable manner and have safeguards to prevent security threats and minimize safety risks. Secondly, the system should also strive for transparency and explainability. So here, relevant information about the system's inputs and outputs should be communicated in an appropriate manner to the appropriate stakeholders. Thirdly, the system should also be fair, meaning that the development of AI across sectors should be fair and equitable to ensure that these systems are not operating in any discriminatory manner. The system should also have appropriate measures around it when it comes to accountability and governance. Accountability here meaning both accountability of the system, but also accountability of those operating the system. And lastly, the 5th principle that those AI providers should strive for is contestability and redress. So there should be mechanisms in place for individuals to dispute, to contest algorithm outcomes. One of the consequences of this, last year, on November 2023, there was a bill introduced in the House of Lords. It's called the Artificial Intelligence Regulation Bill, and it is essentially an attempt to put into practice or to enforce some of the provisions from the AI white paper. Right now, as I record this video, the bill is still pending the second reading in the House of Lords, but in its current form, it has certain interesting points. First of all, it establishes a national AI authority whose main purpose will be to actually regulate AI. It also establishes regulatory principles for the AI authority and AI providers. It asserts the need for regulatory sandboxes. Fourthly, it creates the figure of AI officers. And lastly, it creates the obligation on transparency and IP requirements. Companies should definitely keep an eye on what the ICO, so the country's data protection office, is saying in terms of AI. Apart from the ICO, the UK also has the Centre for Data Ethics and Innovation, who is playing a vital role in shaping the discussion of responsible AI in the country. In June 2023, the centre launched its portfolio of AI assurance techniques. The portfolio provides a catalogue of tools for those designing, developing, deploying, or procuring AI systems. When it comes to consumer protection, companies already has the obligation to rely and to abide by the Equality Act or the Principles for Business and the Consumer Duty regulations to act on aspects related to algorithm discrimination in cases of, for example, customer risk segmentation. When it comes to data protection, AI operators in the UK definitely should already be aware about the UK GDPR, which provides parameters on how to lawfully conduct data collection for training and validating models, and provides certain restrictions on AI decision-making. And lastly, when it comes to the need for risk management-based government, some of the baseline for this can be already inferred from pieces such as the Principles for Business, but also from the PRR rulebook and the Corporate Governance Board responsibilities. Different from the EU or China, but similar to the UK, the US does not have yet a comprehensive horizontal binding AI regulation. At a federal level, the US has focused so far on issuing guidelines, frameworks, whose adherence to is voluntary. With this, the US strategy seeks to allow companies to allow by certain standards of trustworthiness and safety, but without necessarily imposing regulatory compliance requirements on them. So, for example, when you talk about AI policy in the US, one of the most famous documents is the AI Risk Management Framework issued in 2023 by the National Institute of Standards and Technology, the NIST. The risk management framework is quite comprehensive, is quite useful for companies, but the adherence to it is voluntary. So even though there is no enforced AI direct regulation, there are many bills on the matter in the US. So just as a curiosity, only in 2024, so in the last 3 months, there has been at least 9 new introduced bills or executive orders in the case of the government, trying to regulate AI from one or other angle. So here I would like to highlight, for example, the No AI Frauds Act, or the Defiance Act, or the AI Consent Act, all of which in some way or another try to bring some clarity and some protection when we are talking about content that is AI generated. The US has this very lively scenario when it comes to AI regulation, but still with a lot to be seen. Another important feature to talk about the US is that, different from all the other jurisdictions we've talked so far, they also have this state-level dynamic, right? It's a federation. So in the states in the US, they have a very crucial role in shaping the framework of AI regulation, because most of them, different from the federal level, they already have AI-related enforced regulations. So at least 16 states have already enacted some type of AI-related or AI-directed law, even though most of them focus on specific domains of AI, such as elections or defamation, in both of these in the case of deepfakes, consumer protection, equality in hiring process, so on and so forth. So if your company operates in any of the states that have already AI enacted legislation, you should keep an eye on what this legislation says. Coming back now to the federal level, the main regulatory highlight from 2023, I think it's safe to say, it is the Biden administration's executive order, the one called Safe, Secure, and Trustworthy Development and Use of AI.
One thing is clear. To realize the promise of AI and avoid the risk, we need to govern this technology.
The executive order establishes standards for AI safe and secure deployment by public agencies. So it lays out extensive guidance, binding guidance, on requirements for AI transparency, testing, cybersecurity, just to name a few. It is important to highlight that, as I just said, this executive order is applicable only to public agencies, but there is the expectation that there will be some trickle-down effect, and this executive order will actually end up catching the private sector, because these public agencies, more often than not, they actually acquire their AI systems, their AI models and applications in general from the private sector. And to wrap up on the US now, I believe that in a country where the AI regulation is so decentralized, it is important to get to know which are the actors that you should keep an eye on. Companies should also keep an eye on the NIST. So as I said, the National Institute of Standards and Technology. They not only issued the risk management framework for AI, but the executive order, Biden's executive order, also establishes that the NIST will be the institution responsible for reevaluating and assessing any AI that has been deployed or is in use by federal agencies. And if the AI Risk Management Act, which is another bill introduced in Congress, is approved, the NIST will additionally be required to issue guidance requiring federal agencies to incorporate the risk management framework in their AI risk management efforts. So there's a lot of expectation in the NIST, an institution that should be increasingly under the spotlight when it comes to AI regulation. And lastly, another institution to keep an eye on is the FTC. So the FTC, the Federal Trade Commission, is one of the more vocal federal agencies when it comes to AI regulation. So for example, the Algorithm Accountability Act, which is now in Congress, if it is approved, the FTC will have more and more responsibilities of issuing guidance and evaluating AI models across the country. This year is an electoral year in the US, so topics as AI, which are highly polemic, are highly polarized, they tend to be left aside in years like this, so we expect the legislative activity in Congress to slow down a little bit. But on the other hand, these elections are set to be marked by the impact of deepfakes on them. So we should also expect that preemptively, different agencies, different stakeholders in the US should keep a closer and closer eye on deepfakes. So maybe we are about to see more guidance, maybe even more regulation when we are talking about the power of deepfakes, which is one of the many applications of AI. Hopefully with this video and my previous video, it became clearer what are the patterns in the regulatory approaches towards AI. As a rule of thumb, I think it's safe to say that most of the requirements, they go around the need to develop and deploy AI in a manner that is safe, trustworthy, and fair. And therefore, in order to achieve those requirements, most of the regulations will require you to submit your AI systems to certain types of risk management and governance procedures. Besides getting familiarized with the regulations that might be applicable to you, having a look into what international organizations are saying on the matter can also be very helpful.
We need rules and regulations in light of the really scary prospects raised by AI.
So, also, as I said in my previous video, the International Standards Organization, the ISO, they have issued many guidelines already on how to achieve, for example, risk management on AI or a quality management system. And most of the times, implementing those standards will bring your company a lot closer to being in compliance with the regulations from your country. If you like this video, please do not forget to leave your like and subscribe to your channel. I hope to see you soon.